Explain. Negotiation discussions are privileged. The phrase negotiation discussions are privileged means that the content of those discussions is protected from being used as evidence in court or disclosed to others. In other words, what is said during negotiation, for example, settlement talks between parties in a dispute, cannot later be used against someone in litigation or legal proceedings. This protection encourages the parties to speak openly and honestly during negotiations, without fear that their statements will be used as admissions or evidence later. It's sometimes called without prejudice privilege or settlement privilege. So, if two sides are negotiating to settle a dispute, anything said or written as part of those negotiations is generally confidential and inadmissible in court, unless both sides agree to waive that privilege. Explain. Only arbitration produces a binding outcome. The phrase "only arbitration produces a binding outcome" means that, among various methods of resolving disputes, like negotiation, mediation, or arbitration, only arbitration results in a decision that the parties are legally required to follow. Here's the breakdown. Negotiation. The parties talk directly and try to reach a voluntary agreement. Outcome. Not binding unless both sides sign a formal agreement. Mediation. A neutral third party, the mediator, helps the parties find common ground. Outcome. Not binding. The mediator doesn't decide, and the parties can walk away. Arbitration. A neutral third party, the arbitrator, listens to both sides and makes a decision. Outcome. Binding. The arbitrator's decision, called an award, is final and enforceable in court, similar to a judgment. So the statement "only arbitration produces a binding outcome" means, if the parties want a final, enforceable decision, they must go to arbitration, because negotiation and mediation alone cannot compel compliance. Question. Which of the following is a purely voluntary method of dispute resolution? A. Litigation. B. Arbitration. C. Mediation. D. Negotiation. Answer. Here's the reasoning behind each option. A. Litigation. Litigation means going to court before a judge. The judge makes a legally enforceable decision. Once the court has jurisdiction, parties can be compelled to participate and obey the judgment. Not voluntary because the outcome is imposed by the court. It is not correct. B. Arbitration. In arbitration, a neutral arbitrator hears the dispute and makes a decision. The decision is usually binding and enforceable. Even though parties may voluntarily agree to arbitrate initially, the final decision is imposed once arbitration begins. Not purely voluntary because the result is binding coercive. It is not correct. C. Mediation. A mediator helps the parties communicate and try to settle. The mediator cannot force a decision. However, the process still involves a third party guiding the discussion. Voluntary in outcome, but not considered the purely voluntary method in this question because the mediator actively facilitates the process. D. Negotiation. The parties communicate directly with each other. No judge, arbitrator, or mediator imposes anything. Either party can walk away at any time. Any agreement happens only if both sides freely consent. Option D, negotiation, is the correct answer. Because it is the most purely voluntary process, there is no forcing, no imposed decision, and complete party control. A useful comparison. Method, third party, binding outcome, voluntary, negotiation. No. No. Fully voluntary. Mediation. Yes. Facilitator. No. Mostly voluntary. Arbitration. Yes. Decision maker. Yes. Partly coercive. Litigation. Judge. Yes. Coercive. Question. Which of the following is not an advantage of negotiation? A. The parties control the process. B. It is less costly than mediation, arbitration, or litigation. C. It ensures final resolution of the dispute. D. No party is forced to live with a result which it did not agree to. Answer. Option A. The parties control the process. White heavy checkmark. This is an advantage of negotiation. The parties decide when to meet, what to discuss, whether to settle, and the terms of any agreement. No judge, arbitrator, or mediator imposes rules or a decision. So this statement is true. Option B. It is less costly than mediation, arbitration, or litigation. White heavy checkmark. This is also an advantage. Negotiation usually involves fewer formal procedures, less paperwork, no hearing fees, and often no third party neutral. Therefore, it is generally the cheapest dispute resolution method. So this is also true. Option C. It ensures final resolution of the dispute. Crossmark. This is not an advantage of negotiation. So this is the correct answer. Explanation. Negotiation does not guarantee a settlement. Either party can refuse to compromise, walk away, or continue the dispute. If negotiation fails, the parties may still need mediation, arbitration, or litigation. So negotiation does not ensure a final resolution. White heavy checkmark. Therefore, C is the correct answer. Option D. No party is forced to live with a result which it did not agree to. White heavy checkmark. This is an advantage. Negotiation is voluntary. A settlement only happens if both parties agree. Nobody can impose a result on unwilling parties. So this statement describes a real advantage of negotiation. Final answer. Option C. It ensures final resolution of the dispute is correct. Because negotiation is voluntary and may fail, it does not guarantee a final resolution. Question 3. When is arbitration voluntary? A. During the resolution of a dispute. B. Only after a dispute arises. C. During the contract negotiation phase. D. Arbitration is never voluntary. Option C. During the contract negotiation phase is correct. Explanation. Option A. During the resolution of a dispute is not correct. Because it is usually not considered voluntary at this stage. Once parties are already in arbitration, they are generally bound by the arbitration agreement. The arbitrator can impose a binding decision, so the process becomes more coercive binding. Option B, only after a dispute arises, is not fully correct. Parties can agree to arbitrate after a dispute arises, but the key concept tested here is that arbitration becomes voluntary when parties choose it beforehand in a contract. The wording "only after" makes this incorrect. Option C, during the contract negotiation phase, is the correct answer. Because arbitration is voluntary because parties voluntarily agree in advance to include an arbitration clause in their contract. Example: Any dispute arising from this contract shall be resolved by arbitration. At the time of signing the contract, nobody is forced to agree. However, once a dispute occurs, the parties are generally required to arbitrate. Option D, arbitration is never voluntary, is incorrect. Because arbitration begins with voluntary agreement by the parties. That agreement is what gives the arbitrator authority. Key idea: arbitration is voluntary at the agreement stage is correct. Binding coercive at the outcome stage is not correct. That distinction is very important in dispute resolution law. Question: what is the key difference between arbitration and mediation? A. Mediation is binding, while arbitration is not. B. Arbitration is binding, while mediation is not. C. Arbitration involves a judge, while mediation does not. D. Mediation is always court-ordered, while arbitration is not. Answer: correct answer is option B. Arbitration is binding, while mediation is not. Option A. Mediation is binding, while arbitration is not correct. Because mediation does not produce a binding decision unless the parties voluntarily sign a settlement agreement. Arbitration usually results in a binding arbitral award. This statement reverses the reality. Option B. Arbitration is binding, while mediation is not correct. This is the main distinction. Arbitration. The arbitrator makes a decision. The outcome is usually legally binding and enforceable. Mediation. The mediator only helps the parties communicate and negotiate. The mediator cannot impose a decision. Parties may walk away without settling. So this is the key legal difference. Option C. Arbitration involves a judge, while mediation does not, is incorrect. Because arbitration uses an arbitrator, not a judge. Judges are involved in litigation, court proceedings. Option D is mediation is always court-ordered, while arbitration is not, is incorrect. Why? Because mediation is often voluntary. Sometimes courts encourage or require mediation, but not always. Arbitration can also sometimes be required by contract or statute. So always makes this false. Simple memory trick. Arbitration equals arbitrator decides. Mediation equals mediator helps discuss. Or process. Decision maker. Binding. Mediation. Parties themselves. No. Arbitration. Arbitrator. Yes. Arbitrator. An arbitrator is a neutral independent decision maker chosen to resolve a dispute outside of court through a process called arbitration. In engineering, construction, and commercial disputes, arbitrators are commonly used to decide issues involving construction delays, payment disputes, negligence claims, contract interpretation, professional responsibility. Simple definition. An arbitrator functions like a private judge agreed upon by the parties in a contract. Unlike a judge, arbitrators are usually selected by the parties. Proceedings are more private and flexible. Arbitration is based mainly on the contract. Arbitrator. Main role. An arbitrator reviews evidence, hears arguments from both sides, interprets the contract law, makes a binding or enforceable decision, award. Example: engineering context. A contractor claims delay caused by late drawings. The owner argues contractor caused its own delays. The arbitrator examines schedules, emails, site reports, contract clauses, then decides who is responsible, whether compensation or time extension is owed. Key characteristics of arbitration. Feature: arbitration, decision maker, arbitrator, public or private, usually private, based on contract, usually yes, formal court, no, binding decision, usually yes, common in engineering, very common. What arbitrators commonly decide? 1. Contract interpretation. Example: what did the change order clause mean? 2. Delay responsibility. Example: was delay caused by contractor or owner? 3. Standard of care. Example: did the engineer act reasonably? 4. Compensation. Example: is contractor entitled to extra payment? What arbitrators usually cannot do? Arbitrators generally cannot imprison people, impose criminal penalties, revoke engineering licenses, change government laws, decide constitutional matters. Usually, those powers belong to courts, regulators, governments. How arbitrators think, very important for NPPE. Arbitrators focus on fairness, evidence, reasonableness, contract wording, professional conduct. They usually avoid emotional reasoning, extreme punishment, assumptions without evidence. NPPE exam insight. In NPPE questions, arbitrators usually prefer documented decisions, proportional responses, reasonable interpretation, compliance with contract plus ethics. The best answer often sounds balanced, practical, defensible. One-line memory trick. Judge is the public court decision maker. Arbitrator is a private contract-based decision maker. Quick comparison. Role. Main function. Arbitrator resolves private disputes. Judge resolves court legal disputes. Mediator helps parties negotiate. Regulator enforces professional standards. Final takeaway. An arbitrator is an independent, neutral person who resolves disputes, especially contractual and construction disputes, by reviewing evidence and issuing a binding decision outside of court. Question: if a contract does not contain an arbitration clause, can the parties still opt for arbitration? A. No. Arbitration requires a pre-existing clause. B. Yes. Arbitration is always an option if parties agree. C. Only if the court mandates it. D. Only if mediation fails first. Answer is option B. Yes, arbitration is always an option if parties agree. The parties want a private adjudicator whose decision is binding and faster than court. Question: which process best fits? A. Mediation. B. Negotiation. C. Arbitration. D. Small claims. ANS option C. Why? The correct answer is C. Arbitration. Explanation: arbitration involves a private adjudicator, the arbitrator, who hears the case and issues a binding decision. It is typically faster, more efficient, and more confidential than court proceedings. This matches all elements in the question: private plus binding plus faster than court. Why not the other options? Option A: mediation. Facilitated discussion. The mediator does not impose a binding decision. Option B: negotiation. Informal discussion between parties. No third-party decision maker. Option D: small claims. Still part of the court system, not private. This is a classic ADR, alternative dispute resolution, question. When you see binding plus private decision maker, think arbitration immediately. 56. An owner and consultant want help settling a dispute but want to retain control over the outcome. Which process is most suitable? A: litigation. B: mediation. C: appeal. D: summary trial. The correct answer is option B: mediation. Explanation. Mediation involves a neutral third party, mediator, who helps facilitate discussion, but does not impose a decision. The parties retain full control over the outcome, which is exactly what the question emphasizes. Any agreement reached is voluntary and mutually accepted. Why not the others are correct? Option A: litigation. A judge makes the decision. Parties lose control. Option C: appeal. A higher court reviews a prior decision. Still no control over outcome. Option D: summary trial. A simplified court process. Decision is still imposed by a judge. Key NPPE takeaway. Control over outcome. Mediation. Binding third-party decision. Arbitration. Question 58. A dispute involves highly technical delay analysis and multiple parties. The process chosen should balance speed, cost, and expertise. Which chapter theme is engaged? A: dispute resolution method selection. B: criminal charging. C: registration reciprocity. D: privacy consent. ANS. Option A: dispute resolution method selection.